The lawyer for accused number 5 in the Senzo Meyiwa murder trial says her client has been hard done because she was not informed about the second docket. Advocate Zandile Mshololo says the non-disclosure of this docket has denied her client, that's Fisokuhle Ntuli, a fair trial. The controversial document implicates those who were in the room when Meyiwa was shot dead back in 2014. Ntuli and 4 others stand accused of the football star's murder. That trial is currently being heard on the based on the first docket in the High Court sitting in Pretoria. So let's get you a sense of what to make of these developments now. Bring in Professor Koos Malan from the University of Pretoria. Prof, great to have you on the program. Thank you so much indeed for making time to chat to us. Let's begin by just understanding what's actually taking place here. We're told that Zandile Mshololo has brought forward what's called a special entry application. What exactly is she asking the court to do?
It's fairly exceptional. Whenever an irregularity occurs in a case, it is there actually for everybody to see, and in this case it is there for everybody to see. That is to the extent that there was in fact an irregularity. The fact of the matter is that we have here two dockets. The implication of the second docket is that there is in fact additional evidence over and above the evidence contained in the docket that forms the basis of the present case. Now, that is in fact a very peculiar kind of scenario, because in the normal course of events, the following should be happening. The police should properly investigate the case and then identify the person or persons that should be standing trial for the alleged crime. In this particular case, there were in fact 2 separate investigations taking place and 2 sets of accused. 2 sets of suspects in the first instance, and then 2 sets of accused being identified. And then after considering the matter, the police apparently came to the conclusion, together with the prosecutorial authority, that it was better to prosecute the guys that are standing, the accused that are standing trial right at the moment. The 4 accused and later on the 5th that has been added. But when the police so decides, and when the prosecutorial authority so decides, it is their obligation to make all evidence that pertains to the case, either to use it themselves or alternatively then to make it available to the defense. Why is that so? The fundamental idea is that whenever a prosecution takes place, it is not for the state to try to secure a conviction at all costs. That is, for example, over and above other evidence that might pertain to the case that is then ignored or excluded or not disclosed to the court and to the defense. It must be disclosed. So in other words, when the state does not use the evidence themselves, they must make it available to the defense so as to place the defense in a position to use such evidence possibly to their benefit. And this apparently has not occurred in this particular case. Now, there's a dispute on the facts. On the one hand, the state says no. The state prosecutor says the existence of the docket, of the second docket, was in fact disclosed already to the prosecution back in March or April this year. The opposing view of the defense is that no, that is not so. It only came to light now. Now, what the defense now seeks to do is they ask the court to record, so to say, that is to enter this on the record that this in fact takes place. Now, whether or not the court enters this so-called irregularity, I think eventually is actually of no consequence. What should be happening now is this. The docket, the so-called second docket, should in fact be made available to the defense, thus to place the defense in a position to make use of the evidence in that docket in various ways, basically in 2 ways. Firstly, they can obviously use that in cross-examination, in other words, to test the veracity and the reliability of the witnesses called by the state. And let me just say, the forensic witness that has been in the witness dock already back from March, April this year should clearly be confronted with the evidence in the second docket, together with the evidence in the first docket, because apparently, I say apparently because I'm not particularly sure of that, but it appears that he might have come to a different set, a conflicting set of conclusions regarding who should actually be implicated as the real accused in this case.
Right.
So in the first place, then it should be that evidence in the second document could be used as evidence, or rather as material for cross-examination. And then secondly, it could also be used as defense witnesses.
Yeah. Prof, I mean, part of what Zandile Mshololo has argued is that had she known about the second docket, her client perhaps would have even pleaded differently. Do you reckon something like that would take place? In other words, if she has her way, do you reckon the current 5 accused could be given another opportunity to plead in this case?
Look, as I understand it, Advocate Mshololo actually acts only for Ntuli and then other people. In other words, not the people who are not for the first 4. But it is in fact possible. It is in fact possible that the plea might have been different. However, not that much different. Looking at the facts of this particular case, and I'll tell you why. What happened in this case is that they decide, the accused decide to exercise their right to remain silent. In other words, they did not at all disclose a defense. In other words, the way in which they acted is a way that actually put them at zero risk. Whenever you plead, you might put yourself at risk as a result of what you say in your plea explanation. This is not occurred in this case. Through cross-examination and through the defense, through cross-examination and through the defense that which is put to the state witnesses, everything can actually be rectified. You put your defense in two ways. In the first case, you might plead not guilty, and you might then disclose what your defense would be. If you do not do that, if you remain silent, you are, during cross-examination, obligated to put your defense. So this is what should be happening now. And that's why I'm saying what possibly, arguably, might have gone wrong in the first instance, as a result of information not being known at that stage, that is back in March and April, could now be rectified through the way in which the defense on behalf of the accused is put to the state witnesses.
Fascinating. Professor Koos, Malan, thanks very much indeed for helping us make sense of what's taking place. I think fair to say that the way forward is still as clear as mud, but hopefully whatever takes place, justice is served. Koos Malan is a professor with the University of Pretoria. He's with the public law faculty. Once again, thanks very much indeed.